Hi, and I want to welcome you back to RICO Busters. We are talking about the story of Dani Austin and having her children taken away from her by Child Protective Services here in, what county is this?
Isabella County, Michigan.
Isabella County, Michigan. And I've got with me Ted Visner. Ted is a victim's advocate, something that I've been at for a while now myself. In fighting all these cases of government injustices against we the people. And I've invited Ted to this set today because Ted is very familiar with the court rules, the legal process that's going on here. And I just might add that it's up to all of us to start becoming familiar with the box that is around the government, or supposed to be around the government, via the laws and the court rules and the Constitution and things like this. These are the guidelines and the instructions that the government is supposed to be abiding by to ensure that our rights are guaranteed as they're supposed to be. But what's happening is that a bastardization of these rules. They are doing these rules in such a way that it adds color of law, and it's not really the implementation of the law itself that's being used. So if you can elaborate a little bit, let's just start by saying what are the main issues here with regard to Dani's case. What was wrong with the way this hearing was conducted? They give her a call 2 hours ahead of time, tell her she's got to be in court. What's wrong with going to the court?
Well, the court rules that apply and pertain to this case in particular, and all CPS cases, is there's a notice requirement for respondent parents, and there's a notice requirement for non-respondent parents. And I think the one that they're playing on to get away with this notice defect is the Michigan court rule that requires notice for a non-respondent, and they're taking that and they're applying that to the respondent parent. What that means is the definition of notice for a non-respondent parent is they call them up on the phone and say, hey, you need to come to court. And in the Dani Austin case, that's exactly what happened. Danielle got a call 2 hours before the hearing, excuse me, and was invited to come play in their court proceedings. When she should have been served 7 days prior to the hearing.
You say that kind of like come play in their sandbox.
Exactly. That's exactly what it's like. And you know, there's court rules in the child protective proceedings that say if Daniel Austin had ignored that phone call, that invitation to play in their sandbox, as you put it, she would have had to been summoned to court, and the hearing would have had to been adjourned. And since she's not been given the opportunity to put up a defense, her children would have to have been returned to her. And ultimately, the hearing on the 23rd was adjourned because the father was never noticed. Okay, but the same court failed to recognize the mother had never been noticed either, as required by law.
And could we get into a little bit of the specifics? Because we will have the ability, and we do have the ability to scan these documents and provide them firsthand so the public can see. And we want to remind you that it's very possible that Dani Austin will never get to see the jury that she needs to get to deal with this. And so we know for a fact from our past shows that we try to get to a grand jury ourselves. We can't do that either. So it really boils down to you as the viewer being part of the court of public opinion that we are appealing to. And not only for the resolve of this case or for your opinion about this case, but also for the untold numbers of other cases that are out there that really require you as the viewer to get involved, and to help your neighbor, to support the other people around you, to know and be familiar with the laws supporting your own case. That box that's around the government that's around you. So go ahead. We're going to start talking about these laws here and how they were used under false color to deprive Dani Austin of her rights.
I'd like to thank you for bringing that up again, because since I've asserted myself as a victim advocate, I've been taking calls from all over the country. And in fact, I wear out the battery on my phone multiple times a day, and my headset, and I'm constantly recharging things so I can try and speak to everybody that gives me a call. And from what I've found, this practice is not only relevant here in Michigan, but it's relevant throughout the United States. And what we're getting at here is the intentional deprivation of rights under color of law. And I think I may have even coined a new phrase. I call it the color of government. And that's a pretty significant statement. We've got these actors pretending to be our officials, and they're not even following the rule sets that are established, their own rules.
Well, and that's the color of government that Stephanie Smith, the CPS person, was using on Dani Austin, when she basically said, "We're doing you a favor by having the taking this to the family. What is it? Family
first.
Family first. Oh, this is a favor. Well, guess what? It's
a
not
requirement
a favor.
of law.
It's a requirement of law. It's your box. You have to do that. If you don't do that, you're up the creek."
Well, and the reason for that is the liability. See, CPS can now show they brought in family first, and those efforts failed.
Under color of what? 24 hours.
Color of government. Yeah, under 20. The requirement to bring them in doesn't stipulate that they need to be given a chance. So they call them on the phone. And it's a volunteer organization. They're non-biased. They're not motivated by anything other than the well-being of the children.
And they might not even be funded.
I think they're funded, but not federally. They're privately funded through churches and so forth, and their mission is the welfare and the safety of the children. So when they're brought in as a kind of like an oversight thing. And if they're not given an opportunity to function in that capacity, they might as well have not gotten the call in the first place.
Very correct. Very correct.
So, and I would also like, because this goes towards what we were talking about earlier, there's, once these children are sucked out of those homes, CPS at that point, after making that bold move, they can't just give the kids back. After they're pulled out of the home...
That's an admission of wrongdoing there, isn't it?
Exactly. Mm-hmm. So CPS is in a position to try and minimize the liability for kidnapping by making sure that all of their allegations and all of their actions show to be substantiated throughout this entire process, whether they were valid in the first place or not.
Hence the reason for court procedures, rules of civil procedures, the Michigan court rules, and all this other kind of stuff. Although we'll find out a little bit later that the Michigan court rules, the Michigan Supreme Court, which is in charge of the oversight of all this legalese, is complicit in providing them with the way out in this particular circumstance by Dani, and we'll get into the specifics of it. The Michigan court rules is by just showing up. There is a rule that says that there is a waiver of all rights just by showing up.
Well, first off, David, there is such a rule, but it is not possible to waive your natural rights.
That's correct.
It's not possible. Whether the Michigan Supreme Court says you can or not, it's not possible. And that's what brings in the Michigan Supreme Court as being complicit.
That's because the rules are for the government and not for us. It's for the rules to guarantee our rights. Just by showing up, and it's the government that's supposed to be familiar with these rules and these instructions, not us. And Dani Austin goes into the court, and all she's caring about is the welfare of her children and getting those kids back, because she was told earlier that day those kids have been taken away and given to the grandparents.
Well, again, and hopefully I can help more people than just those in Michigan. And I've got volunteers now in different states that are helping me put together the same paperwork as they apply in the different states, because it's paramount to force the courts into complying with their own rules. Because when they don't, we have the intentional deprivation of due process under color of law, color of government, which is a federal crime under Title 18, Sections 241 and 242. Feel free to look that up. And before we really get rolling here, David, I'd like to encourage folks that are going through issues with CPS that have an active case going to grab 3 pieces of paper from your court file. You may not have them. Okay, you may need to watch this video and then replay it again once you have these 3 documents. The first one that you should have to follow along with us, and we're gonna show you how these parallels seem to be prevalent through everybody's CPS court case. Okay, the first one is the summons and the petition. The first 2 pages of the summons and petition are the summons. The petition starts on page 3 and is another 3 pages, and then any attached allegations come after that. So if you don't have this from your own court case file, and keep in mind here, there's 3 different case files. CPS has a case file, DHS has a case file, and your county court has the court file.
DHS being Department of Health,
Human
Services.
And the second paper or document that you need to find from your court case, it should just be one page. Actually, there's 4 pages altogether. But you want to find the proof of service for the original summons and petition. And this is important because it has directions to the process server right on the top. It says, to process server, you are to serve the summons and petition in accordance with MCR 3.920B5. And we'll get into that later, but it's a direction. It's a direct. The process server is being directed to serve you these documents, the summons and petition, in accordance with this court rule, and that's very important. And the next paper that you should find and put your hands on to follow along here would be the notice of appearance. If you had a court-appointed lawyer, you're going to want to get the date and time that he filed his appearance. Michigan court rules stipulate that if a court appoints an attorney, the attorney will file his notice of appearance in those proceedings. I think it's within a day or so. I'd have to look that up again.
And in this case here for Danny, this guy Tony Moses, didn't even sign this thing until 5 days later.
That's correct. So in every essence, Daniel Austin was being advised by an attorney, allegedly, as to what she should do when he hadn't filed his notice of appearance, and never did for another 5 days. So, I mean, this could have been some guy off the street.
It could have been.
And may as well have been.
Right.
So just roll over and play dead is basically what he said. I mean, I could have done that if I had something to gain by it. And the janitor up at the courthouse could have done that, I guess.
But you or the janitor would probably be charged with a criminal offense of practicing law without a license or the unauthorized practice of law, which this man should be prosecuted for himself because he was advising something without having a contract, without himself.
Oh, he's still liable.
Exactly.
Tony Moses, you're still liable, buddy. And we'll get to that more later, but the fourth paper out of your court file would be what you want to have to follow along is the order after preliminary hearing. And depending on what county you're in, it might vary a little bit, but it's 4 pages. So anyways, with the documentation in hand,
let's because we have been going for just a little while. Before we get into the nitty-gritty of this, I want to take a quick break. We'll be right back. And we want to welcome you back to RICO Busters. I'm David Scheid, and I'm interviewing Ted Visner. He's a victim's advocate, working with Dani Austin on how to evaluate what the heck happened with her case here and what is going on and what we can do about it. So let's just go ahead and dig right into those Michigan court rules and the laws. And see what we can evaluate about this.
What I'd like to start with is to demonstrate how things were supposed to happen in accordance with the paperwork provided up to this point in the court case. Okay, we've got the 4 pieces of paper. We've got the proof of service, the summons and petition, order to appear, the order after the preliminary hearing, and the proof of service. I think I mentioned, but also the notice of appearance from the court-appointed attorney. Okay, we'll start with the proof of service. To the process server, you are to serve the summons and petition in accordance with MCR 3.920 B5. Okay, and I happen to have that right here. Time of service. A summons shall be personally served at least 7 days before trial or child protective dispositional review hearing. Now what this is saying is that Daniel Austin was supposed to be served with the summons and petition
7 days.
7 days before the hearing.
Not 2 hours.
Not 3 minutes. 7 days. Okay, that's the direction of the process server. In this case, Wendy Yost, who is a juvenile register, whatever that is, signed this proof of service in front of a notary. I can't make out his or her name. It looks like Ballard. Mr. or Mrs. Ballard, whatever.
Now, I know when we were talking about this case yesterday with Dani, Dani said that she never was directly handed this. That this actually came to her from that court-appointed attorney, Tony Moses, after the hearing. And what this person, Wendy Yost, has done is that she has signed and had notarized as a legal document her statement saying that she did serve this. Am I correct? That
Yeah.
she did serve this directly to Danielle, which never occurred. In fact,
That's felony perjury.
that is felony perjury.
From
We're
what I
talking about crimes here.
From what I understand, it's a 15-year felony perjury. And a lawyer told me that, so I don't have any reason not to believe that. That's 15-year felony perjury. And what it does say is that, again, Daniel Austin was served. Now, had Daniel Austin's court-appointed attorney been served, his name would have been here as having been personally served the summons and petition by Wendy Yost. But it doesn't say that.
And it gets better. It gets better.
Well, worser is what I would say, but you're right.
Right. I mean,
there's a lot more to it than that.
this is evidence.
Okay.
Evidence of crimes.
Wendy Yost attests under penalty of perjury in front of a notary that she personally served Daniel Austin on 7/23/2014, the same day as the hearing, at, it even has the time here, at 2:57 p.m. Keep in mind, Daniel Austin's hearing was at 3 p.m., 3 minutes after this proof of service was allegedly served on Daniel Austin personally, and it never was, according to Danielle. Danielle claims that she never even saw the summons and petition until after the court hearing. So I'd like to get right back over to the summons and petition, because the fraud doesn't end there. The fraud is rampant throughout this entire case.
Well, and one of the things that struck me most, the fact that this whole summons thing says that it's supposed to be given 7 days, right?
Right.
Okay. At some point along the line, it's got to go from the person that signed, the judge that signed this thing.
And that's what we're getting to right here.
Okay.
The summons is 2 pages. The first page gives notice. You are ordered to appear in person before the court for a hearing on the allegations in the attached petition. The appearance of the children named above is necessary. Okay, so this is a summons demanding Dani Austin and her 3 children report to court on this date, which is 7/23/2014, at 3 p.m. And it gives courtroom C. That's where they're supposed to be. Now, the second page of the summons, order to appear, is signed by a judge. In this case, it's William T. Urban, bar number 30654. Okay, William T. Urban signed this summons, this order to appear to a hearing for 4 people to appear on the same exact day that he signed it. He signed it on 7/23/2014. There's a signature. It's even a raised court seal or court stamp.
Mm-hmm. This is an official government document that's placed into the official government record saying that on this particular date, this judge signed it 7/23, right? 7/23/2014, saying with the knowledge, clear knowledge of the Michigan court rules that says that he's supposed to be given 7 days at least to the party that's being served with this summons petition, and he is signing it saying that this person has to show up later that day.
Not just Danielle, but Danielle and her 3 children. That's 4 people ordered by William T. Urban to appear immediately.
This is irrational.
As soon as you can.
Yeah.
You know, in violation of just every summons. You know, every summons has a different time requirement. This violates all of them.
I'd say with that kind of knowledge behind him, if this was a specialist in any way.
And thanks for bringing that up. This brings up another point. Why didn't Wendy Yost get the summons to serve on Danielle and with her proof of service and say, hey, look, William, I'm supposed to serve this summons and petition in accordance with MCR 3.920B5.
Because it's right on her proof of service.
And the judge would say, well, are you questioning me? Are you questioning my authority? I gave you a job to do, go do it. That must be what happened. But if I was Wendy Yost...
I think what happened was this.
If I was Wendy Yost and told to serve a summons and petition in accordance with directions provided right on the proof of service, I would have looked those up because that's my butt, that's my job. I got to do things right. So I would have went up to William T. Urban and said, look, you just signed this summons. I'm supposed to serve this 7 days before the hearing in accordance with the court rule listed at the top of the petition as part of my directions to serve it. What are you trying to do? Get me fired?
And the judge would say, you are fired, because I got a whole line of people here that'll do what I tell them to do because I make the rules here. I just know that.
Well, in any event...
Am I being a little facetious here? No, I'm being factual.
Well, I'm sure, you know, the unemployment rate has never been higher, and well, not according to Obama, but, you know, people are out of work, and what happens when you don't follow the orders of a judge, even the unlawful ones? Like you said, there's a lot of people that want to put food on their table and willing to do just about anything.
So, you know, the government officials will portray themselves as having all this power, and they are. This is only the authorized power that we're giving them. Yet they're portraying themselves as having this power that, and they're acting benevolently in giving Dani this other opportunity, you know, to work with family first, when actually it's by law that they have to be doing this.
That's correct, David.
So now, what other documents have we got here that you want to introduce? We've already covered the 7 days. We've covered that MCR. What was it?
3.920B5.
Correct.
Which is the 7 days required for a summons. And what I'd like to talk about now, that's kind of the lead-in to the second part of this, is where the Michigan Supreme Court is complicit with trapping these parents inside of a jurisdiction that was unlawfully obtained and is being criminally maintained.
Okay.
And that's in Michigan Court Rule 3.920, Section H.
So we're talking about the same 3.920, right?
Correct.
It's just a different section of the same thing on one hand, they're given 7 days to come in, but on the other hand, what?
They're taking it away.
Okay? If you show up.
If you show up.
How does it read?
Section H of Michigan Court Rule 3.920 reads as follows. Notice defects. The appearance and participation of a party at a hearing is waiver by that party of defects in service, which are terminal, with respect to that hearing, unless objections regarding the specific defect are placed on the record.
So let's just take a look at what the word defects means. In other words, if they don't follow the rules, if they don't do what they're supposed to be doing, then they are creating defects in the procedure, in the documents, and all this. Those defects, which you say are terminal, means they can't do this, start over, case end, that kind of stuff, right? Especially when we're talking about a first hearing.
What we're talking about is jurisdiction. The court has to achieve jurisdiction over the parties and over the subject matter. Okay, when all parties are not noticed to the proceedings they're asked to participate in, the court has failed to obtain jurisdiction. Everything done after that is a nullity. It doesn't exist. The court orders have no validity. They have no meaning. And this case is full of court orders. Primarily the removal of children.
Mm-hmm.
So, if you think about this from you're in the hot seat perspective, you've been called to come to court, and your children have already been taken, and you're sitting there going,
what do I do?
Your brain's froze. You're a deer in the headlights already.
Mm-hmm.
And I guess, according to this, you're supposed to be able to object to notice defects. And at the same time, know that you were supposed to be served 7 days beforehand. All of this, everything that happened to Daniel Austin happened in 13 minutes in a courtroom. And that includes introduction to her lawyer.
Well, and I would imagine it's that lawyer that's supposed to be noticing the defects. Am I right?
That's exactly right.
And that lawyer is supposed to have 7 days to be able to review this stuff. Assuming that the court has appointed this lawyer at the same time they're making the order that she's got to show up, supposedly 7 days later. But in this case, she's got to show up the same day. They give the lawyer to her. He doesn't ask her to sign anything. He's acting on her behalf without her having any recollection, any knowledge of what's going on here. It's all being sprung on her at the last minute, and she's scared
to death.
That's the words that I was thinking of.
Well, you brought up another real good point, and we just had to deal with this. Now that these unlawful proceedings, the lawyers have failed to object. Daniel's had 2 lawyers. She had court-appointed lawyer Tony Moses.
Mm-hmm.
And he failed to object, make any notice or any objection on the record to the fact that his client wasn't properly served. She went out and spent $3,000 to hire this Kelly Lambert guy, and he failed to object.
Now, as I recall, that she did put something in writing or put into the record that she was firing that first attorney, even if he...
Well, she didn't have to fire the first one because she hired the second one, and the second one took care of getting rid of the first one.
Okay.
By filing his notice of appearance in his place, and we have a copy of that right out of the file. And Kelly Lambert failed to object on Danielle's behalf, even though she'd asked him to. Look, you have to object. I never got a copy of the summons and complaint. Kelly Lambert didn't want to object. Okay, and you can hear his testimony on my YouTube channel titled Kelly Lambert. And that's ultimately why he was fired before the February 10th hearing in this case. Here are a couple clips of attorney Kelly Lambert, and I'd like you to listen to these and tell me if you think this man should have been paid for what he did, or if he should be jailed for what he did. Keep in mind, he's speaking right now about the person who's paid him for his legal expertise. The entire segment can be found on my YouTube channel. Check it out.
There's definitely been a breakdown of the attorney-client relationship here. My client has sought to terminate me more than once. This is the third time, frankly, all within the last week or so. Currently, at this point in time, she believes she's being persecuted. She believes the government is after her. She believes there are conspiracies left and right. She believes that something may happen to her, which was a discussion at the last dispositional review. She believes that her children have been kidnapped, etc., etc. Her rights have been violated, both federal and state.
And if you listen to the hearing in that case in its entirety, you'll hear Judge Mark Duthie tell Daniel Austin she doesn't have a choice. She has to have a court-appointed lawyer. And when somebody's represented in court, the person, the subject of the allegations, they don't get a voice in court.
All rise. Following case involving the following minors, the Austin minors, Madison, Marcus, and Michael, 14099NA. It's the first time I've been involved with this case. I think it's been heard by the referee a couple of times. He's on behalf of the department. Mr. Mel is here on behalf of Dad. Can you state your name, sir?
Very awesome.
Okay. And is it Mr. Lamb?
Mr. Lambert, Your Honor. Good morning.
On behalf of Mom, can you state your name?
Danielle Austin.
Okay, well, we're here because Mom apparently filed a motion. Well, why don't you go ahead, ma'am, and argue your motion? Go ahead.
Well, first off, Your Honor, I'd like to confirm that you are operating on your oath and bond.
Pardon me?
Your Honor, I'd like to confirm that you are operating on your oath and bond.
Pardon me?
I would like for you to confirm that you
I'm
are
not going
operating.
to answer any questions for you. You can argue your motion, go ahead. You're not asking me a thing.
Okay. Well, I feel that everything that was stated in my motion is pretty much clear. There was a lack of service and, due process, that my rights were violated. I mean, I came into court and I didn't know what was going on or what the allegations were against me.
I read the file. Isn't it true you made admissions in this case, ma'am?
Yes.
Continue.
But I mean, everything happened so fast and there weren't emergency circumstances to do that to me. I mean, to have proper lawful notice, so that way I know what's going on in the case. I can get my own attorney and have the time, to be able to prepare my case, which there wasn't. I mean, I was notified 2 hours before it was time to go into court.
You talking about the original emergency hearing?
Yes.
Anything else you'd like to say, ma'am? Okay. Well, your motion has no legal merit. Okay? It just doesn't. It's nonsensical. It doesn't make any sense. You had a retained lawyer when you made admissions. You could have gone to trial. You could have asked for a jury trial. The prosecutor would have had an obligation to present a case and convince a jury that your kids fell within the jurisdiction of the court. But for whatever reason, you made admissions. The court accepted jurisdiction of this case. The court has jurisdiction of this case. There's no merit in your motion, and your motion is denied. Now, I don't know if you have the capability of representing yourself in the future. But I'm going to appoint the Isabella County Public Defender to have a lawyer present for the next court hearing we have. And you'll have to talk to that person, and you'll have to decide if you want to represent yourself. But at a minimum, I'm going to have a lawyer sitting at the table with you to guide and help you if needed. So between now and your next hearing, when's the next review? Between now and April 13th, we'll have a new lawyer appointed. You'll have to meet with the attorney and figure out how you want to deal with your case. But I'm not going to have you come into court on your own, trying to represent and litigate your own interests when the other side has a lawyer and when everyone else has a lawyer. You need to get advice from a person skilled in the law. So that's the order of the court. The motion is denied. Ms. Scully, please prepare an order that the court will sign.
All right, so I'd like to really discuss what part does the Michigan Supreme Court play in all of this here when they're regulating the procedures and the law and the court rules and everything else that's going on here.
Well, the Michigan Supreme Court makes up the court rules. The court rules were intended to govern the court staff and the court officers. And it's been expounded to cover us all with our consent. And people don't really understand
Unknown
this.
consent.
Exactly.
Right.
It's an unknown consent. But what's transpiring here is the Michigan Supreme Court, not being a legislative body of our government, are creating these rules which are enforced like laws, essentially making the Michigan Supreme Court a part of the legislature.
I can see that.
And
So-
that's a usurped power.
because we are being subjected to the penalties of whatever occurs. So that first court rule on the previous page there, first court rule basically says that it lays out that they're supposed to get these 7 days. Okay, well then not giving somebody 7 days is a defect. It's a terminal defect. And then when you walk in the door with 2 hours notice and all you want to know is what do you have to do to make sure that your kids are okay and then you get your kids back once you've been told that they've been taken away from you, by this other court rule, which was made by the Michigan Supreme Court, you are waiving your rights. You are waiving those defects. And you're not even knowing you're doing it. And this is something, if you can, did you read that yet?
I'll read it again here. We had a little issue with our lighting, but it's very important for the folks watching this and the people that have similar cases to understand that their participation in the case is actually a participation in the fraud against them, in the perpetuance of the cases against them, is a waiver by you or by whoever's participating of the defects in service. And this court rule, Michigan Court Rule 3.920, Section H, notice defects, and I'll just read it again here real quick. The appearance and participation of a party at a hearing is waiver by that party of defects in service with respect to that hearing unless objections regarding the specific defect, which are terminal to the proceedings themselves, are placed on the record. And what that means is, if you go to court and you don't know about this rule and you don't first raise your objection, the Michigan Supreme Court is saying that you're waiving your right to object in the future to notice defects or the lack of service. And the Michigan Supreme Court can't make a court rule for an individual that's unaware of this to waive due process rights. Due process rights are a natural right. They're inalienable. Okay, the Michigan Supreme Court can't tell you that you're waiving a right that's inalienable.
So how do they alleviate that? They hand you stooge number one that's standing over here and they say, that's your court-appointed attorney. He is you in disguise. You know, he's going to represent you. And so by him not acting and speaking up on your behalf, because he knows those rules, or he's supposed to know those rules, they're court rules.
Well, trust me, they're all familiar with this particular court rule because it traps people in the jurisdiction. This rule basically does away with due process. This rule allows Prosecutor Risa Scully to steamroll over these respondent parents in CPS cases because the moment they appear, they don't have rights anymore. And all is forgiven according to the Michigan Supreme Court with regard to notice defects.
That's the defects are all forgiven. It doesn't matter that you didn't do that. It doesn't matter that you didn't follow the process. It doesn't matter that you have violated their rights by having those defects. They're all forgiven because that person showed up.
Exactly.
And even if they had any objections, if they didn't raise them to you, attorney, as long as you don't say anything to the court, we're just going to let this thing go right over their head, and we're going to take away their rights, we're going to take away their kids, and we're going to move on. That's the railroad track. It's moving on.
Well, the significance here in my mind is that all of these bar members are familiar with this rule. They all understand that with this rule on the books, created and maintained by the Michigan Supreme Court, they have a back door that they know exists before they even initiate the proceedings in the first place. You know, if I knew that due process could be written off by the Michigan Supreme Court with regard to a respondent mother or respondent father, I probably wouldn't pay any attention either to the lawful requirements to get them there in the first place. And that's where the problem is. That, you know, they're relying on this rule before the proceedings even begin. And it's obvious and it's apparent when you're supposed to be served 7 days before the hearing. But we don't have to worry about that because there's a back door. You know, and this back, actually it's a trap door in the floor. I mean, once the parent stands on it, they pull the trigger, bam, they're done. And this is what's going on in Danielle Austin's case. She expected her first lawyer to zealously represent her and bring up the fact that she hadn't been properly served. He didn't do the job. Her parents helped her come up with financing for a paid lawyer who also failed to bring up the objection to the defects in service that were obvious in her case. She served 3 minutes before the court hearing and she wasn't even served herself. So you see, the paid lawyer or not paid lawyer, a court-appointed attorney or a paid attorney, and you can hear Kelly Lambert in his own testimony, his own words, tell the court that he would never, follow through with an objection related to defects in service because it would nullify the entire proceedings. And there's 8 bar members there, all getting paid to be there. And all of a sudden they don't have a reason to be there anymore because somebody's saying, hey, these proceedings are a nullity in their entirety.
That's correct. And that means that there's taxpayer money wasted. And if that information gets out, we have people that need to be replaced in their jobs. And whether it's the judge that's elected by the people or whether it's who they want to appoint as their
well, the people that are there now need to go to jail.
That's correct.
After due process. You know, it's funny. These people so eager to deny poor, defenseless mothers in stripping their family, destroying their families, just obliterating these families without due process. These very same individuals are going to be begging for due process.
And with that, I'd like to invite Dani Austin to come back in. We will be right back, and we'll have a little dialogue going on between Dani and Ted about this situation. We'll see you in a minute.